In this session, we will see about the Memorandum of Association in Companies Act. Memorandum of Association is a fundamental document filed along with other papers for the incorporation. This document gives the details about the company, what is the name of the company, where it will be situated, that is the registered office, what are the purposes, that is the object clause, and what will be the liability of the shareholders and what will be the capital size. Section 2, subsection 56 of the Companies Act defines memorandum as memorandum of association of a company as originally framed or altered from time to time in pursuance of any previous company law or present act. So it is not giving any detailed explanation on memorandum of association. This says this is a memorandum of association prepared as per the present act or the previous act. It includes all the alteration also. Then what the memorandum should contain? Section 4 subsection 1 says that. Section 4 subsection 1. The memorandum should contain the name of the company, registered office of the company, the object of the company, the liability of the shareholders and the capital regarding the capital. Based on that, we can say that memorandum of association should contain 5 clauses. One is name clause, registered office clause, object clause, liability clause and the capital clause. We will see one by one. Name clause. Section 4, subsection 2 and 3 deals with the name. The name, what should be the name? It should mention the name. What are the permissible names for the company? Some conditions are there. It says it should not be undesirable for the central government. Then it should not resemble the name of the existing company. It should not give the impression that company has the patronage of the state government or the central government. It should not be against any law. First, undesirable. What is undesirable? The government is issuing regarding the rules regarding the naming of companies. Companies incorporation rules gives the details. What shall be the desirable, what shall be undesirable. If a company is giving a name which is similar to another company, it is undesirable. For example, SR Industries is there. One company, SR Industries Limited. Another person should not go with the application S.R Industries. Or SR Industries, one company is there, another person cannot go with the new name, New SR Limited. So it should not be similar to that. If there is a limited liability partnership, then also the government will not permit that name. Like this, what indications are given, and based on the rules you have to give. What is undesirable is given in the government rules. Next, it should not resemble the another company. It should not be against the trademark. We already seen it is like SR Industries, S.R Industries or New SR Industries. It should not similar to the other company. Next, it should not give the impression that the company has a patronage of state government or central government. For example, government is using the word development board. There are many development board. A company cannot come with a name Rajan Development Board Limited. Then definitely the people will think that this is a government company. It should not give the impression that it has a patronage of the central government or state government. One person may start company with the New Indian Recruitment Board Limited. Definitely people will think that this is a government company. This type of names central government will avoid it. So the third is, it should not give the impression that patronage, impression that this company is having the patronage of the state government or central government. Fourth is, it should not against a law. It should not go against any law. For example, trademark law is there. Trademark Act. Trademark means one person is having a established and he is doing the business. some emblem, everything is he has a trademark. He should not go against that. He cannot change the emblem slightly and use that emblem in his company or change the name slightly. That is not permissible. That is against that. There is an act called the Emblems Act 1950. This act says a person cannot use the United Nations emblem or Indian government emblem. All these conditions are there. The act says that you cannot use the word Mahatma Gandhi or Nehru or Shivaji. These names are prohibited. You cannot use it in the company. These are the conditions. You have to see the central government website and availability to be seen, and a name we can take. 4 conditions: not undesirable to the central government, not similar to any existing company, or does not give the impression that a company is having a patronage of central government or state government. 4th is not against any law. There is another provision in section 8. All companies should include the name limited in their name. So company should have the name limited. But the government may permit not to omit that limited, the word limited. Limited need not be used by that company for the charity companies which have been incorporated for the purpose of charities operations. Charity objects like science, technology, improvement, environment, sports, education, all these things. In that case, government will permit, no need to add the limited in your company name. Another condition for that is the profit should not go by way of dividend. The profit should also be used as used for the charitable activities. So a limited company name should be there in the limited should be there in the name, but exception is for charitable institutions. It should be painted at all places, the name and papers, section 12. Regarding the name, we can reserve the name for 60 days. If a person is going to start a company, he can apply to the registrar according to section 4, subsection 4. He will reserve the name for 60 days. But in case if he has taken the name by giving incorrect or wrong information, then penalty will be there. It may go up to 1 lakh rupees. The company will strike down the name from the register, or the registrar will strike down the name from his register. He will ask the company to change the name by passing an ordinary resolution, or he will go for filing a winding up petition. This is regarding name clause. The name should be mentioned properly. If it is not mentioned properly, it may end up in personal liability for the person who has signed. There is a case, Dermatine Company Limited versus Ashworth. Dermatine Company Limited versus Ashworth. Here the rubber stamp was so big, he was signing a promissory note, bill of exchange. What happened, this limited went outside the area of the paper. Bill of exchange, only the company name was affixed. The limited was out of space of the promissory note. These people signed. The end, that name was there, limited company was not there. The court held that it is not purposefully done. The company will be liable, not the directors. But there is another case, Henton versus Adelman. In this case, the company name was L&R Agencies, but these people signed the documents as LR Agencies. LR Agencies Limited signed, but actually the name is L&R Agencies Limited. The court held that this is not a company liability because company name is not mentioned. It is a director's individual liability. Next is change of name. Change of name is permitted. Section 13 subsection 2, 3, 4 deals with the change of name. You can change the name, but central government approval is required. but no approval is required if the change of name is for removing the private limited from for removing the word private from the company name. For example, Raja Private Limited now change it to Rajan Company Limited. So only private is taken, then there is no approval. It has to be filed with the registrar, the special resolution to be passed, central government approval copy, both have to be filed with the registrar of companies. He will issue a fresh certificate of incorporation. Next we will see the registered office clause. The Memorandum Association should say where is the registered officer. That section 12 says the company should intimate the office, a registered office, to the registrar within 15 days. Within 15 days, the registered office address should be communicated to the registrar, and within 30 days, the registered office verification should be done. As per the prescribed procedure, they will prescribe the procedure. It has to be verified and the verification should be submitted. Third is, the registered office, the company name should be placed on a board. Everywhere it should be displayed, the name. Apart from that, every correspondence letter name should be mentioned along with the registered office address. Now we will see the change of registered office. The section 13, subsection 4 to 6 deals with that. There may be 4 type of change of office. One is within the city. Number 2, within the jurisdiction of the same registrar of company. Number 3, 2 registrar of companies in the same state from one area going to another. 4th is other state. If it is within the city, no permission is required. If it is one registrar office within his jurisdiction, for example, the person is in Chennai, company is in Chennai, it is going to Vellore. Same jurisdiction of the same registrar of company. In this case, pass the resolution, submit to the registrar, he will issue a certificate. Same registrar's jurisdiction area. Next, same state, 2 jurisdiction areas. For example, Tamil Nadu, there are 2 registrar of company. Assume that one is at Chennai, another person is Madurai. A company operating from Madurai, registered from Madurai registrar office, is going to Chennai. Same state, but there are 2 registrars. In that case, application should be submitted to the regional director. He will give approval. Then along with the approval and the special resolution, they have to approach both the registrar of companies for the shifting. 4th position is one state to another state. If it is one state to another state, central government approval is required. Central government, before giving approval, will see that all the interest of the creditors is taken care of, or the creditors' consent is obtained, or adequate security provided to these people. Only after that they will give the approval. Along with the certified copy of the approval and special resolution, they have to approach both the registrar of companies. New certificate of registration, incorporation will be issued by the registrar of companies. So regarding change of registered office, 4 situations: one within the city, one within the registrar's jurisdiction, one within the state but different registrar's jurisdiction, 4th is out of the state. Regarding the object class and other classes, we will see in the next session.